All right, quick intro here to the plunking video of creating a counter affidavit with their documents, use them against them. So what I've done in this next application using Loom is side by side, I'm showing you their complaint against you or your client, and you take their documents and you just plunk them into the counter affidavit. Then the smaller part of the video will be taking the counter affidavit content and making it your answer. As I always counsel, the counter affidavit travels with you everywhere. See all my videos on creating a counter affidavit. So leave those up there, Cindy. See all my videos on how to create an answer. So I always try to micromanage down for you. So this video is to show you side by side how I do these cases. I put the complaint up, and then next to it, I use two screens, but Loom doesn't allow you to do that, so I've put it on one screen. And I literally tear it apart, copy, and then cut and paste. They will give you the arguments to use against them. So it's always funny, and clients report this to me all the time that use my methods. They argue against their own documents because you're taking their stuff. And now they're yelling at the judge. You go, Judge, this is theirs. Judge, this is theirs. And in this case, this example I've done for you, this is a first. This is very rare. They got a trust document that says all the loans were put into a trust. Usually you're alleging it and you've got to go search. So check it out. That's the video. I hope it helps you. It's rather long, but just take what I've said in the video and use it for your own answer. I hope this helps you. Thank you. All right. So I always talk in terms on the videos of using their own documents against them, and then taking their documents and plunking it down into your counter affidavit. That's the most important document of the whole process. And as I always say, the counter affidavit basically follows you through every course of the litigation, depending on how far it gets. So before you is the screen of a lawsuit against my client. And here's what's called the summons. This is Michigan, but it's in every state. And they have to check off a box to see the orange. There's no other pending action. You'll be surprised how many times they say there's no other pending action, and you find out there was, because it's all done by a machine. So that machine breaks down, but they don't have to worry about the generality of their pleadings because 90% of cases usually get defaulted or settled early. As I always say, we live in that 10% and we're trying to expand that. So here's the first thing you look at, and you'll see on the right of the screen is the affidavit. So we're going to plunk whatever basically helps us, the client or you, into the affidavit. The counter affidavit, which is everything. So let's tear apart. I always say tear apart the complaint page by page. So here's their first page. It's Galaxy International. There's something that's called Galaxy International Purchasing. There's no doubt they're debt buyers, right? So that's irrelevant. They're never going to come back with the defense. We're not debt collectors. So Exhibit A is, they say, holds all the terms in the contract and everything. And then number 4 says, all rights and interests in the account were transferred and assigned to the plaintiff. First of all, the account, it's a debt. So there's already a separation within their own language between the account and the debt. The debt is something that's normally securitized. They keep the servicing rights or the account. They can't sue you on the servicing rights. But I digress. What are we doing with this information? We are plunking it. So first of all, we find out where's the original creditor. Do you see the original creditor in that? That's where it should be. In fact, there are state laws, especially in Michigan, you have to list the name of the original creditor. It is not here. It would take 5 seconds. So why do they not do that? Because they use a general form for every single case. But again, that's on them. They have the burden of proof. So you'll see, let's follow this arrow. And right there, the lawsuit does not mention the original creditor. So that's right in your affidavit. And now we reference the bill of sale. So let's look at the bill of sale, which is the thing that shows your debt or your client's debt jumping into the ownership of Galaxy. So in other words, we must have a document, as we recall. This is a web bank debt. I should back up here. I apologize. Doing a bad job for you, but I'll try to do a better one. See, it's a borrower agreement between, and there it is, web bank. So the original creditor is web bank. So if anything's getting sold, the initial original creditor is web bank. They sell to whomever they want. You just have to show a chain of title. So that is the actual contract. And it's quite a large one, obviously. There's web bank's privacy notice. So we know it's a web bank debt. No doubt about that. There's a web bank credit score notice. So, and the most important document in any loan is the truth in lending disclosure statement. That is a count of action or a complaint on its own if that's wrongfully filled out. But here we only need it to show it is a web bank debt. There's a lender, original creditor. If it's getting sold, it has to be first sold by a web bank for there to be a chain of title that is perfected. So we travel over to our affidavit. We've said, hey, it doesn't mention the original creditor, web bank. And the bill of sale is not a sale of anything. So what are we talking about when we say that? So we'll look at the bill of sale. And that says lending club. Well, as we know so far, on January 22nd, 2021, supposedly when this is effectuated, there is no web bank to lending club for lending club to sell Galaxy International. You recall the pleading number 4 in the complaint says everything, the right title and interest was transferred, and it's just a general statement, but you've got to be specific for a specific chain of title, specific even more to your debt with your specific account number. So lending club that has at this point not received anything on January 22nd is professing, let's see if they're going to say they're selling something. Lending Club Corporation, a Delaware corporation, and Galaxy, blah, 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 executed an account purchase agreement. They say it. It's a forward flow agreement. So all they're saying is there's a forward flow agreement. There's not selling anything. It should say sold a bunch of debt from A to B. The terms of the agreement will govern the bill of sale. Fair enough. All right. For value received and careful consider mutual covenants exist set for blah, 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 blah. The investors. Whoa. Where's Lending Club? Where's Web Bank? Where's Galaxy International? I thought this was a bill of sale. But this is talking about investors, unnamed investors. Pursuant to the agreement on January 22nd, the closing date, each investor, what investor, will sell a pool of accounts, that's not a debt, held by such investors. Lending Club represents and warrants that each of the undersigned investors, other than Lending Club, other than where Lending Club is the investor, has executed a limited power of attorney. So that's all this really is. You can call it a rose is a rose is a rose. This is a weed. It's a limited power of attorney between investor and Lending Club. It means each investor says, we don't have the time to sign everything. We're giving Lending Club the power to sign for us. Fair enough. But that's not a bill of sale. That's a limited power of attorney. So that doesn't mean anything as far as anything getting sold. First of all, remember, Lending Club at this point doesn't have any rights to give to anybody. And so it can only give the rights of the investor, which we have not seen any assignments. I guess there's one or two investors. Oh, whoa. Oh, my goodness. Where are all the assignments to all these investors, if you will, and they're all trusts, of your client or your debt, specifically transferring, for example, Lending Club Corp to MPLI Capital Holdings? You see it? I don't. You don't. But if you're going to show it, you got to prove it. I didn't ask you to do this. They did that. So how does that work its way into our PLUNK? So we've looked at the bill of sale, and we say the bill of sale is not a sale of anything, but rather just a notice of investors of a limited power of attorney. And then we show the court the bill of sale. The lawsuit's filed in Michigan, but the loan agreement states that the Utah law governs these proceedings. Does it say that? Let's take a look. We look at the agreement, and this is what you do in your plunking efforts. So, do we have a governing law provision? Come on, baby. I know you got it. Come on, I'm fishing. I know you're there. Got you, I think. Liability, 12, assignment. That's a whole plate wrong, too. Limitation, choice of law, right there. See that? Choice of law. So we then, let's get out of that. We then take our choice of law, and it says Utah. And we put that, we plunk. We copy the image, we plunk right there where the court doesn't have to go search. We help them out. Oh boy, that's that's all right. Anyway, so that's where that belongs. See if it would copy with save image as copy with formatting. Let's take an hour to format that. But the point being is that plunks right here. See if it'll come out properly there. Yeah, it's a choice of law, goes right there. And now your next step is on January 25th, WebBank is the original creditor and lender in this case, 2023, and claims to sell something to Lending Club. That is not true, but I'm just using a form affidavit. So there is the bill of sale. And it is WebBank is here and lender and claims to sell something to Lending Club. That is not true, as we don't have that. What we have is the bill of sale of Lending Club selling. Let's just get rid of that. The bill of sale. The bill of sale from Lending Club with no specific account number, account or debt being transferred that is connected to me shows that the document just mentions investors. Indeed, the Lending Club bill of sale is just a best way to put it, I'll use their own language, a limited power of attorney. So you see that? Limited power of attorney. And that's what it says in the bill of sale. There are no assignments showing each investor. Remember we went down all these? So that's in our affidavit. There are no assignments showing how each investor in the bill of sale received the account and from whom to be able to assign anything to the seller. This appears to, we just said that up there. Lastly, who is Brendan Pace? And where is the authorization to sign for all these? So in many states, you can't just say, he's saying he's general counsel, of whom and who authorized him to sign for all these many entities. Got to say it. That's the proof. There's no proof of WebBank selling anything to Galaxy or Lending Club. Now here's the killer. So there is a broken. So here's the killer. And I'm going to put, in fact, you're going to love this one. This is what they gave me. So WebBank finally arises at 127. So let's look at the bill of sale, 122.
So 5 days later, when Lending Club is selling something to Galaxy it doesn't have, understand? So it doesn't have it because nothing is sold from WebBank to Lending Club. That's missing. But check this out. Certificate of loan sale. WebBank, and that's the initial seller, is hereby certifies that it is a transferor, that's or, and it originates loans that are serviced, not owned, by Lending Club. Fair enough. And that says in the agreement. Each of the loans identified by loan number and attached Exhibit A, each loan, was originated. When anything's originated, look for a securitization. Within 1 week of origination, transferred or otherwise conveyed to Solar Gray Trust each loan. Oh my God, how did we find out? They told us. So the date of this loan that my client took out is 2020, 2/17/2020, and a week later, by their own words, it was transferred to Solar Gray Trust, each loan identified, right? That is big for you. That means WebBank's divested itself of the loan already. And again, that's part of, we've talked about that, securitization. They originate the loan, you get the money, and within a couple of days, a week, it gets sent to a bunch of securitized trusts. See all this nonsense. That's where those guys are taking pieces and tranches. And so that, if it will go, I don't know if it will because we got to do some plunking. This is your whole case right here. You're going to plunk. So 15, in fact, let's see if it comes out nicely or it's just a blur. It's a blur. It's okay. I think you get my point. I think you smell what I'm cooking here. Look at this. Let's say copy with imaging. They admitted, WebBank, that they've given everything to a bunch of investors a week after. And they are saying this 5 days after supposedly Lending Club, which has no ownership rights, but is now really a power of attorney for the investors. So Lending Club would have to show how it got all these rights after a week after the origination. So they've done that somewhat. But how did Lending Club receive the debts when there are no records of this? So let's see if we can plunk that in. Within 1 week of origination, yeah, okay, good. So let's see, 5. You're seeing this piecemeal, but I think you get what I'm doing here. So we're plunking. Has not, further, Lending Club's not sold anything to anyone, and the chain of title between the entities in this case was broken in that Lending Club, is claiming to sell something. So, yeah, this is what happens on live. To sell something to Galaxy on a bill of sale. However, a review of the bill of sale shows no sale of any debts or loans between Lending Club and Galaxy, just a mention of purchase agreement, but no language of Lending Club selling anything to Galaxy. It's just a bill of sale for investors or each investor to sell something to Galaxy. And by the way, there's nothing showing them selling anything to Galaxy. So you got a whole plate of wrong. And there's the bill of sale that you've plunked in for the court. There are no assignments showing how each investor received the account and from whom. To be able to sell anything to the seller, you want to highlight that for the court. How did each investor, who did each investor, some of the following, receive the accounts to become sellers from? Ugh, I don't like that sentence at all, so that's gone. And then the client says, I've never heard of any of these companies, and I see no assignments. So that's the thing that you or your client is signing. It also says the lawyers are attorneys in the practice of debt collection. It does say that if you look, because you want to, it may seem like a small thing, but you want to attach everything. It becomes a wall. So they're telling everybody we're attorneys in the practice of debt collection. So I put in the affidavit right below the amount of the debt that the processor had to have read to know how much I was being sued for, because in this case, the processor told the client, you owe $30,000. You better call the attorney. They never say, hey, you better call your attorney. And look at this. They put the number right on the, so you're kind of being forced away from representing yourself, and they're going to try and force you into a deal on a debt they don't owe, as you can tell. They don't own. And then you have peripherally, this is an account stated lawsuit, have not paid anything to Galaxy. So let's quickly go over the coolness of this. It's a web bank debt. It's not in the actual lawsuit. So web bank must sell something to somebody. There's a choice of law provision. This has to be brought in Utah. In this case, it's a Michigan case. So that's already a defect. This stuff adds up. That $30,000 debt, I can tell you, was resolved in a way the client could not be happier without revealing anything. I hope that's the good way. See, it's a web bank case, debt, web bank. So it's got to be something from web bank to lending club. So is anything being sold here? Web bank to, nope, to a trust, totally away from lending club. So was the servicer in its role as servicer during the period owned the loan? So there's nothing to lending club for it to become even a power of attorney, and nobody has sold anything to specific to the investors, just this trust. So you've got so many branches and tranches and capillaries going off from this debt. It took me a couple of minutes to explain it to the other side, and that case was resolved very favorably. They ran me around, so I was happy in the way they resolved my client's claims under a counterclaim. I filed a counterclaim. Now, I had an answer, so my next spot is to show you what I did with the affidavit and how it went in to the answer. And now in our continued plunking, we've taken the affidavit. Here's the affidavit we created, and we're going to plunk some more. And we now have our answer. Here is our answer. And what we're going to do is just take everything we have in our counter affidavit. And you can see there's a mention of a bill of sale, the lending club. Boom, right there. For the lending clubs, not sold anything to anyone. You remember we talked about that. There are no assignments showing how each investor received the account. We talked about that. It was placed into a secure trust or asset-backed security. Really, was it? Yes. How do we know? Because their documents say within a week of WebBank giving the money and contracting with the client, it was all transferred by WebBank to Solar Gray Trust. In fact, most damning, it shows a loan was sent to Solar Gray Trust and no one else or any of the entities signing off on the bill of trust. Brendan Pace, the signer on many trusts and entities attached to the bill of sale, has no authority anywhere to sign off on the bill of sale, which is really just a power of attorney and is selling nothing. Lending club has no ownership right to sell anything. And indeed, that's what we talked about. Lending club can say anything it wants. Further, lending club was not sold anything to anyone, and the chain of title between the entities in this case was broken. So everything you do in your power of attorney, I'm saying that because that's what they really are, a power of attorney. Lending club is nothing because it has not received any rights to give to anybody. But everything in your counter affidavit plunks, goes boom into your answer. We did a counterclaim. Guess what the focal point of that counterclaim was? It was the fact that Solar Gray Trust has the ownership of the debt, and the bill of sale is not a bill of sale of anything, just a power of attorney. In fact, all they're saying is there's a forward flow agreement between these parties. It doesn't say anything's being sold. So you bring that to light through your affidavit, explain it to court. That's attached to your answer. Your answer says exactly what your counter affidavit says. And you see it jumps right in there. It's all done for you once you've done your counter affidavit. It's the hardest part, and it's not that hard. You're just taking their documents, as I said previously, and plunking their good stuff. Actually, it's your good stuff, their bad stuff, right into in your counter affidavit, which refutes anything they have to say. This one, again, is the lawsuit is filed in Michigan, but the loan agreement states that Utah law governs these proceedings. So I haven't done that in my answer. I'm going to do that so I can show you evidence of plunking. Oh, we mentioned the Green case. Green case is on hold, but the law that got the Green case to that's great favorable opinion for all of us still exists. It's always good law. Just the actual opinion is on hold. So you're reiterating to the court what your counter affidavit already says. And you would say, like I just said, you go plunk, sent to Gola. Lending Club has no ownership right. The lawsuit's filed in Michigan, but the loan agreement states that Utah. So you're using their own loan agreement against them. Court's just going to say, Galaxy, just let them go. You clearly screwed this up. And I'm not saying that's what happened, but I'm saying everybody's happy except Galaxy. So in conclusion, there's no assignment of bill of sale specific to the defendant, no pleadings identifying how many of the numerous trust entities receiving and passing on the debt were legally able to receive and pass on the debt. This case should be dismissed as plaintiff has no standing to sue. That's your number one reason why you win every time. You got to have standing to sue. And this backs up the fact that you don't. And then all that information goes into your counter affidavit. So kind of a lengthy explanation for you. This is my first, I'm using a download from loom.com for my continued efforts to microsize this into making this easier. So you create the counter affidavit like I showed you. That is your bedrock of your case, and you plunk that information into your answer. And of course, over here, you clean up the answer, but that's how I do it. That's exactly how I do it. It just travels. Their documents travel from boom to boom to boom into my paperwork, which crushes them. And so when they're arguing against me, guess what they're arguing against? Their own documents. So it's all good. You got them. Keep rocking it. I hope this helped. Bye now.
Okay, so that's it. You just have taken everything, you've plunked it into whatever you want to use it. So the counter affidavit is everything. Create the counter affidavit. You have an answer. You can add it to your counterclaim. It goes into your affirmative defenses. Somebody's filing something against you, a summary disposition, Exhibit 1, their own documents incorporated in your counter affidavit. And your answer is being supported by it. It just travels with you everywhere. You can show the court your side of things. There are these companies, SoloSuit being, I think, the largest one, that say, here's an answer. Admit, deny, admit, deny. Specifically in Michigan, under the account stated statute, you automatically lose if you don't have a counter affidavit. It's called that because they're normally bringing an affidavit against you. You have to counter that. The actual statute here in Michigan is MCL 600.2145 says if the other side fails to answer, it's automatically a given. See all my videos on how to do counter affidavits that say that. I'm sure that's the case in many other states that you're in. So get that counter affidavit created from their own documents, plunk the relevant information into your answer supporting why you deny something, You can also plunk that into the counterclaim, into responses to motions. It's a beautiful thing. I hope this micromanaged way I've done it hopefully explains things for you. Good luck.